Hi, I'm Tom Bradford. In this video, I'm going to highlight something for you if you're coming to the UK on a startup or innovator visa. It's in relation to your tax position, and you'll be aware, and you can see from this diagram, that if you want to qualify for indefinite leave to remain, then you need to be in the UK for most of the year. So that means that you can only be outside of the UK for 180 days. So just to focus in on one of these years, if you're beginning on the startup visa, and your maximum absence period in any rolling 12-month period is 180 days. That means you've got to be in the UK for 185 days. Now, this is important because from a tax perspective, if you're in the UK for more than 183 days, then you will be tax resident. Now, what's the significance of this? Well, it's that if you're a tax resident, the default position is that you'll pay UK tax on your worldwide income and gains, whether or not they're brought in to the UK or not. So most of my clients will have a business and investments abroad that will be generating revenue while they're in the UK. And you can be caught out if you haven't thought about this and planned for it. Because look, if you've got to be in the UK for 185 days, then you will be tax resident, and then therefore the default position would be that would be taxable. However, there is a way around this, and I'm going to deal with that in this video. So as a matter of law, if your domicile is abroad other than in the UK, in other words, if your domicile is overseas, then you can choose to pay tax on what's known as the remittance basis for a period of time. So just to give you this rule in a nutshell, if you're resident and domiciled or deemed domiciled in the UK, then you need to pay tax on the arising basis. So as I say, this means that you pay UK tax on your worldwide income and gains for the tax year in which they arise. And it doesn't matter whether you bring your foreign income or proceeds from foreign gains to the UK. But if you're resident and not domiciled in the UK, you still need to pay UK tax on your UK income and gains on the arising basis, of course, but you can choose to pay UK tax on your foreign income and foreign gains either on the arising basis or on the remittance basis of taxation. So that means you only pay tax on the sums that are remitted to the UK or brought into the UK. So let's just have a look at your typical journey on the startup visa or innovator visa. You'll be beginning on the startup visa for 2 years, and then you'll switch. Just bear with me because this is a live stream. I'm just zooming in and out. You'll switch at year 2 into the innovator visa, and then you'll spend 3 years on the innovator visa, and then assuming you meet the success criterion after the innovator visa, then you'll qualify for permanent residence at year 5. Of course, if you go straight onto the innovator visa, then it'll be year 3. And then you need to spend an extra year in the UK until you get to British citizenship. So in other words, until the point at which you qualify to naturalize as a British citizen. So that's the typical journey. Now, as for the tax position, let me just go to the next slide. This is the statutory residence test, and statutory residence test applies for the purposes of establishing whether you are a resident in the UK for tax purposes, and this is relevant for UK income tax, capital gains tax, corporation tax, and inheritance tax. And you're automatically deemed resident in the UK if you spend 183 days or more in the UK in the relevant year. There are other ways in which you're deemed to be tax resident, but that's the most important one for our purposes, given the, as I say, the interface with the immigration requirements. And then you begin on this journey. Now I've highlighted in this diagram the all-important 183 days, and at the same time the 185 day requirement if you're to get permanent residence. Now there's different ways of structuring this, because you can be outside of the UK for longer than 180 days without necessarily breaching your conditions, and then if you're on the innovator visa, for example, you could simply extend, because you can extend indefinitely on the innovator visa and spend less than that time in each year. But at some point, if you want to secure permanent residence, you're going to need to structure it differently to make sure you are in for that period. And then from that point, if not before, you will be tax resident. So at that point, as I say, the default position is then you then pay tax on your foreign income and gains, subject only to double taxation agreements, etc. But this is obviously that's jurisdiction specific, and I'm focusing here on UK resident non-domicile status and how you can leverage that. So I think the key point here is that you can opt for the remittance basis even while you're tax resident for the full period, first 5 years while you're on this journey, and then avoid having to pay UK tax on your foreign income and gains in broad terms. And that can make a massive difference, especially if you have significant assets and income from overseas. Now, one of the potential traps here is that while you're in the process of applying for indefinite leave to remain and naturalizing as a British citizen, you might at some point have to make relevant declarations which could have an impact on whether you are deemed or viewed as a matter of law to be domiciled in the UK. Let me give you an example, and I'll just zoom in on this part of the diagram. When you apply to naturalise as a British citizen, you have to complete Form AN. And this is the question. I'll just zoom in a bit so you can see this. Tell us in which country you intend to have your main home if you're naturalised. If this country is outside of the UK, and you're not married to or the civil partner of a British citizen, etc., then include a letter of explanation. Now, this declaration could cause you an issue. Tell us in which country you intend to have your main home if you're naturalised. It's when answering this sort of question that you'll need to convey, if it is the case, that the UK is not to be your permanent home. And there was a famous case in the then House of Lords in which a declaration was made to that effect, and that was deemed to be important on the circumstances of a particular case in determining that someone was not domiciled in the UK. But it's perfectly possible to be domiciled abroad and have UK citizenship, and of course permanent residence or indefinite leave to remain, as it's called here in the UK. The reason I say that is just with reference to the HMRC flowchart, for example, which accurately summarises the legal position. So have a look at this flowchart in terms to determine your own particular facts, or to get a steer on them. But this is the position for most of my clients. If they're asked, what are your plans for the future, they may well say either no firm plans or their plans are to leave the UK in the long term. That could be the distant future. So let's just say it's no firm plans. The next question, just zoom in on this. Next question is where were you born, another country, and then go to chart 3. So if we go to chart 3, where was your father born, in the UK or in another country? Another country. Do you have current personal links with that country? Yes. And then the question is, do you have current personal links with the country or territory of your own birth? If the answer is yes, then you're domiciled outside of the UK. Let me just zoom in on that for you. Now that and this just underscores, and it is the case, that there's all of these concepts are different. The concept of indefinite leave to remain, of tax residency, of domicile, of citizenship are all distinct concepts. So you can have one without having the other. Now, just to highlight that point, let's just go back to chart 1. Where is my domicile? What are your plans for the future? And then if your plans are to leave the UK, then you go to chart 4. And on chart 4, this is a bit more detailed. It asks, where were you born? And then the question, just zoom in on this. Where were you born? Another country. Where was your father born? And then the relevant one is usually this bottom one, another country other than while his father was working outside of the UK for a limited period. And then in which country are most of your personal links? And then another country rather than the UK. And then the answer is, or the outcome is, you are domiciled outside of the UK. So you can see here that it is possible to go through this journey and maintain non-domiciled status, so UK res non-dom status as it's abbreviated, but you need to be careful when you're completing the applications for permanent, as I use permanent residence as an abbreviation, indefinite leave to remain, and when you're naturalizing. But if you do this, then you can potentially pay no tax or very little tax on your non-UK on your non-UK income and gains. That is UK tax. And to go, just to extend this into the long term, you can enjoy this status for up to 15 years. And you can see from this diagram, sorry if it's small, I'm struggling to fit this into one slide, but you can maintain non-domiciled status for 15 years in the UK, as I say, subject to navigating it correctly. And under the statutory formalised codified regime, you pay 30,000 only from years 7 to 12, and then from years 12 to 15 you'd pay 60,000 a year as a one-off, a single payment for each year. Now that is really potentially a huge tax saving, and really a tax efficient approach which may work for many, and it's something on which I would say you should take advice. Clearly the immigration and the tax advice is intertwined here. If you'd like to speak with me and my tax colleagues and the tax and accountancy partners who I work with, then I'd be very happy to speak with you. This is the reason why the UK is still deemed by some to be a tax haven, if you like. And of course, there's other ways of structuring in terms of the foreign element of your income and paying income overseas, other ways of having tax efficient structures through corporations, trusts, and other approaches, which mean that you can ultimately be in the UK and not be paying tax on your foreign income and gains in the UK, but also be paying little or no tax on your foreign income and gains abroad. The latter only applies to perhaps a very small category of people, but it's important to remember. And I certainly wouldn't want anyone coming to the UK who's my client and who has not taken advice on the tax position beforehand. Most of my clients do have significant businesses and income from abroad. So I hope this was a brief but helpful flagging of the issues. If you would like to speak with me, please don't hesitate to get in touch for a free consultation. You can get me on the contact details below. I will see you in the next video.